suffered a driveway robbery. The dad had been pretty well brutalized at gunpoint. And that kind of was a wake-up call to him. He had never owned a firearm before. He went out and bought a 12-gauge shotgun, had someone teach him how to use it, and teach his wife and son how to use it. 2011, the wife and the then 14-year-old son arrive home to find a burglar on the premises. The son runs and grabs the shotgun. If the guy had just fled, there's no doubt in my mind no shot would have been fired. Instead, he came at this young man's mother, and he's reaching what we call in the courts a furtive movement. A movement that is consistent with going for a weapon and not reasonably consistent with anything else under the circumstances. And the history of it is a whole lot of common sense aphorisms apply to the courts. If it waddles like a duck, and it quacks like a duck, and it's got webbed feet and a bill like a duck, it's reasonable and prudent for you all to believe you are dealing with a duck. Okay, and they should point out that with that in mind, it is unwise to impersonate a duck during duck season. The young man fired one shot from the 12-gauge and killed the intruder instantly. The intruder turned out not to be armed. Was he faking to try to scare them away or something? We'll never know. He's dead. Well, it went to the state's attorney's office. Family hired a criminal defense lawyer. Before too long, the investigation was complete, and the state's attorney told the criminal defense lawyer, look, I'm telling you right now, tell your clients to save their legal fees. I am not going to prosecute this case. Well, the attorney says, fine, but there has been a massive multi-million-dollar lawsuit filed against the family. Could we get a memorandum of closure on this from your office? Brief digression. The memorandum of closure is a statement from the prosecutor's office that says, we have investigated this case, here is the disposition we're going to make of it. Might be we're going to put it to the grand jury, might be we've already put it to the grand jury and they've indicted, or they haven't indicted, or whatever. The grand jury not having indicted you is no defense to the lawsuit under 776032. Okay? That simply means that for whatever reason they didn't think, or the prosecutor's office not bringing the case isn't either, for the same reason. It simply means they didn't think they could prove it to a beyond a reasonable doubt standard, which is the standard for the criminal court. Beyond a reasonable doubt, the law professors vary on it. Some will tell you 95% certainty, some will tell you 99.9% certainty. But it's irrelevant to the civil courts, because in the civil court with the lawsuit, it's the same standard you have with the so-called stand your ground hearing, preponderance of evidence. If you can't convince people 99.9% this guy's guilty, no reasonable doubt at all, do you think you might be able to say, yeah, but more likely than not, he is guilty? Your classic example, who's old enough to remember the O.J. Simpson trial? He was acquitted in criminal court. They could not prove beyond a reasonable doubt. Frankly, the way they handled the evidence, if I had been a juror, I probably would have come into the same verdict. Another jury absolutely hammered him on the civil, and the difference was the standards of evidence. So what you really need for it's not a get out of jail free card, it's not a get out of lawsuit free card. What you need is a memorandum of closure that specifically states, we've investigated it and we found it to be self-defense, or we found it to be justifiable. That is the stake in the heart of the unmeritorious civil case. Unmeritorious is a legal term for BS. Or if the judge in the 776-032 hearing is found in favor of the defendant, that's it, stake in the heart again. The original memorandum of closure said we're not prosecuting. If you read the details of the investigation and each conclusion of each element, it could be seen as, yeah, we're not prosecuting it because it's a justifiable homicide and we would have shot the guy ourselves. But it didn't say it in so many words. Finally, it does go in 2015, 4 years later. 4 years of accumulated legal fees, accumulated costs, and the costs can be huge. If you're paying thousands of dollars a day for each expert witness, and that's not just for their testimony, that's for the time they take assessing the case, the the time in pretrial depositions, pretrial statements, which essentially the other side cross-examines and finds out what your expert is going to say. That's hundreds of dollars an hour for each of those. All the documents that are involved. Some services charge $3 per page for double and triple spaced legal depositions that run hundreds of pages. 2015, at last, the 776-032 hearing is held. By that time, the other side's theory of the case has become it was negligent for the family to allow this child, this 14-year-old flighty child, to put his hands on a loaded shotgun. In other words, negligent to allow a 14-year-old kid to save his mother's life. How many moms do we have in here? How many of you would kind of like your 14-year-old son to be able to pick up a gun and stop your murder in time? Ka-ching. And that's what the court said too. Now, why did they go with the negligent side? Well, here's the deal. They were looking for the homeowner's insurance. Lawsuits seek deep pockets. Is anybody in this room so rich and so stupid that if I sued you and won $1 million judgment against you tomorrow, you've got a liquid million laying around unprotected that I could seize to satisfy the judgment? Anybody in here both that rich and that stupid? If he raised his hand, I'll buy half of that. How many of y'all How many of y'all have at least $1 million homeowner liability insurance? Ka-ching, and that's what they're looking for. But if they go into their theory of the case, is that ruthless, bloodthirsty child gunned down the decedent for nothing. And he did it deliberately with malice in his heart. The attorney for the insurance company is going to spring to his feet and say, "Thank you, Mr. Plaintiff's lawyer. Your Honor, move to dismiss my client, the insurance company, because it's right here in our policy. We don't cover that." Go home tonight, look at your homeowner liability, or your auto liability, which will come into play if you had to shoot a carjacker, the road rage guy that ran you off the road. All those policies expressly exempt the company for having to pay for what's called a willful tort, your deliberate malicious act that harmed another. But how does the other side get around that? If you've given them some hook where they could say, ooh, negligence, that was it. It was negligence. They negligently entrusted that firearm to that unstable, emotionally, blah, blah, blah child. Well, negligence is exactly what liability insurance is for. So, judge saw through it. Stake in the heart. Seems to be dead. They have appealed, and the new appeal, God knows why, I guess they figure the family has enough money to at least maybe recoup some of their losses and bring in the case. Their new theory is going to be malicious shooting by the 14-year-old, and that one goes to his hearing next month in South Florida. It's 5 years after the shooting. Remember that the next time somebody says, oh, all I've got to do is say I acted in self-defense. In Florida law says I can outlaw you free. Doesn't work that way, sports fans. So why the confusion in the terminology? Yeah, when you've got 4 elements in a legislative package, you can't give it 4 names. You've got to give it one catchy name that's going to resonate with the public, so they'll write their legislator and say, hey, vote for this. Stand your ground seems to be the one. So that's why all this, even though only one element of it involved the rescinding of the retreat requirement, that's why the whole thing became known as stand your ground laws. In the Zimmerman case, this past week, when they were talking about Angela Corey's defeat in Jacksonville, someone was talking about it in the infamous Zimmerman stand your ground case. It was never a stand your ground case. And I can say that with some authority. I was retained as conditionally as expert witness by Zimmerman's initial attorney, Craig Sonner. I say conditionally because I never take a case till I've seen all the discovery. The state not only hadn't given Sonner all the discovery, the state never, through the course of trial, gave all the discovery they were supposed to the defense attorney who wound up. When Sonner left the case, the whole team he had assembled left with him. I consulted for an hour in second quarter 2012 with Mark O'Mara and Sean West, who did, I thought, a brilliant job of defending the kid. And basically, overall, I thought their defense was textbook. The facts in the case were entirely different from what the media had presented. There was no stand your ground issue. Once you are down with your head being banged on the concrete, and you've got the grass stains on the back of your jacket and the bloody lacerations in your back of your scalp to prove it, retreat is not an option. You are under attack, it's fight or die. His attorneys understood it. The prosecution, I think, pretty well understood it. Sonner certainly understood it. And later, talking to George Zimmerman, he never thought it was a stand your ground case like. But to this day, you hear the two of them interlinked. That's what happens when people get sloppy with the terminology. Essentially, the whole retreat requirement, if you look at it over history of civilization, it has rarely, most countries don't have it. If you're under attack in a place where you have a right to be, the attack is unlawful, you fight back with equal force, you're allowed. Where it came from in the United States, remember so much of our law descends from the English common law, was a centuries-old principle called homicide, se defendendo. If you're taking notes, don't worry, it's in your handout. Essentially, it was a time when, with the upper classes of Britain, the nobleman would say, "You dare to insult me, sir. I slap you across the face with my deerskin glove and challenge you to a duel." And the peasant classes, if you will, of medieval England, whenever thatched roof cottage passed for the pub in the village, two guys get a few too many ales in them, and it's like, "Oh, bloody hell, you don't go out the alley and fight then." And one guy kills another guy, and every time it happens, a family is left without what was then the head of the household. And the lawmakers said, you know what, enough. We've got to institute a requirement. You don't kill over pride, you don't kill over anger. You're required to retreat if you possibly can before you use that level of force. Homicide, se defendendo went so far, and this remains in law here in Florida and elsewhere. I attack you. I decide I'm going to punch the heck out of you. Well, surprise, surprise, you're a better fighter than me, and you're winning the fight. If I turn around and say, "Oh, I give up! I don't know what came over me!" And sure, under the homicide, se defendendo principle then, and now in all 50 states here, you can no longer pursue me and keep pounding on me to teach me the lesson. At the moment I adjured from the conflict, I was still liable for punishment for starting the fight and whatever damage I may have inflicted on you. But if you now came after me and used more force on me, you now had become the initial aggressor and the culprit in a second assault. So that essentially is where the concept came from. But remember, the retreat requirement is still in effect in some states. It has never been demanded unless it can be accomplished in complete safety to oneself and others. Now, another thing you really want to watch for, how many of you all here own firearms? Okay. How many of you have become kind of the resident expert, or friends, family, neighbors, they ask you for advice on this stuff? Okay. One particular thing to warn them about, because a whole lot of the talking heads couldn't tell the difference when this legislation passed. A whole lot of the general public only know from what they saw on TV or read in the newspapers, can't tell the difference between Castle Doctrine and stand your ground. Castle Doctrine speaks strictly to home and curtilage. Curtilage means attached, like the porch of your home, your carport. In some very rural states, it will extend to the barn. In some states, will have case law, how many yards the barn has to be from the farmhouse for it to still be curtilage, possibly the front yard. You saw that to some degree, I think, here in town in the Casey Kasem case, which occurred in the front yard of her home when she was attacked by someone there, most recently. You'll hear people say, well, if I'm attacked in public, I don't have to retreat because I've got Castle Doctrine. If they make that mistake, it's not just a semantic error. Okay, if you are swimming with the sharks in a courtroom, that is blood in the water. If I was cross-examining you, I was trying to nail your hide to the wall. I said, "Sir, what authorized you to carry that gun and use that force in the public park?" "Castle Doctrine." "Look, how you got it?" "Sir, explain to the jury what you perceive castle doctrine to be, well, that's the rule that always said your home is your castle, blah, blah. That's correct, sir. And this happened in the public park. The public park was an extension of the castle. Who was it exactly that made you our king? And you ain't gonna be able to get out of it. It's not just using, it's not like pronouncing somebody's name wrong. When the wrong concepts get used, you have lost your credibility in front of those 12 people that are holding your lives in their hands. How many of y'all in here have done jury duty? Thank you. God bless you for doing that. I've always hoped to do jury duty. In my case, it's just going to be a race to see which side kicks me off first. But I tell my students 3 definitions of a jury. One of them I call the law school definition. I call it that because, with one memorable exception, every attorney I've ever discussed this with said sometime during their 3 years in law school, they heard a law professor say, you know your life is in, you know you're in trouble when your life is in the hands of 12 people too stupid to get out of jury duty. Now, with apologies to the one young person in the room, block your ears, kid, that's bullshit. I use the term advisedly because I hear that word come out of the mouths of so many attorneys, it must be a legal term of ours. There's no such thing as 12 people too stupid to get out of jury duty, and any of you who've gone through the voir dire before you were put on that jury know that. Anybody who wants to get out of it can. The people who stay out of a sense of duty to their community. And those of us who stand in front of them must never forget that. The second definition I give my students comes closer to the truth. I'm from New Hampshire, still a sworn cop up there, but forgive the Yankee-tude. The words getting across, I have my translator in the back row.
That would be helpful.
Permanent, I'm going to need you to translate the lecture later. But basically, I consider myself a recovering Yankee, and I'm getting through it one day at a time, so help me, my friends. But my fellow New Hampshire man, Robert Frost, the poet, said the jury is 12 people who've been assembled to determine who has the best attorney. There's a whole lot more truth in that. The definition I've worked with, starting as an arresting officer in 1972, expert witness since 1979, police prosecutor in the state of New Hampshire since 1988, has served me very well, has served my students well, and I'll recommend it to you. My definition of the jury is it's a 12-headed creature, got a collective IQ well above 1,200, might have as much as half a millennium of life experience, and it's got 12 separately functioning bullshit detectors, at least some of which are going to be turned on and receiving at any given moment in the trial. And what I found is whoever triggers those bullshit detectors first is going to lose. Have your terminology down. Know what your defense will be. How many have heard the term CYA? Sing out what it stands for.
Cover your ass.
All right. You own a gun, you might have to defend your homestead with it. You carry a gun, you might have to defend yourselves or your loved ones on the streets. There's more than 1.3 million Floridians no license to do. For us, CYA should stand for Can You Articulate? Can you explain why you did what you did? And it should also stand for Can You Authenticate? Can you show that what you did was the right thing to do? That it was within what the courts call the mainstream of common custom and practice for dealing with that type of crisis. That it's what a professional, licensed bodyguard or police officer would have done facing that same criminal if it had been him facing you, instead facing the perpetrator instead of you facing that perpetrator. If you could do that, you won't have to worry about which 3 digits come after 776 point. Basically, the truth itself is going to set you free. These laws are not perfect. I think they absolutely were reform legislation at the time they came in. If you followed it, just like in 1987, when Florida passed their prohibition of concealed carry. Now, again, the media people got it wrong. They said, ooh, you used to have to beg and plead and show that your life was in danger to get a carry permit in America. But after those damn Floridians opened the gate and made it shall issue, and anybody with a clean criminal record and character background check, you got one. Now it's gone all over the country. No. Go back and look at the history of concealed carry laws in the United States. They were virtually nil in the pre-Civil War years. The concealed carry permits actually grew out of Reconstruction here in the South. And the white power structure said, holy crap, black folks that we have stepped on since 1619 when the first slave came to Virginia are now going to be free and they can have guns like us. What'll we do? Well, we'll get together. We're going to pass a law. We're going to make it so only good white men like us can get a license to carry a gun. We'll make sure we elect a good white man like us, the sheriff, to issue it to us. But if you look back in history, that's exactly where it came from. You saw it in the urban Northeast in the early 20th century when they were worried about Irish immigrants, Italian immigrants. Either way, it was racist bullshit. You did have some pockets of freedom. Vermont, for as long as any living American can remember, nobody needed a permit to carry a gun. For so many years, more than a century, they were the only state where anybody 21 or over could carry a loaded and concealed handgun without a permit and was simply forbidden to do so if they had a criminal record, had been adjudicated mentally incompetent, or in the exact words of the statute, had malice in their hearts. Today, we have at least 7 states that have gone permitless carry, the Vermont model. The great majority of states prior to 1987 were, as Florida was then, may issue. That meant the issuing authority, the sheriff in the county, the chief of police in the city, whatever, had the option of issuing you a permit. Well, the way it worked out in many places, not all, but many, and in some states most, was that was a translation for, we'll give you the permit if you're white, male, rich, politically connected, and by the way, did you contribute to the sheriff's and the mayor's election campaign? I was like that in Florida until '87. Marion Hammer, Unified Sportsmen of Florida, led the legislative package that gave you the shall issue model that you have now. And that's because things for so many years have been static. For decades, there have been at least 7 states where there was no provision for the ordinary private citizen to get a license to carry a gun and protect themselves and their families and public. Today, there are none. The last, Illinois, went shall issue, I think, 3 years ago. You guys started a wave of reform legislation. Right now, you have nearly 1.5 million people carrying guns in the state to protect their families. The crime rate among that select few is infinitesimal. And usually the so-called crimes are, it's the guy with a permit for the first time, he's not used to having it with him all the time, he forgot it was in his briefcase when he went to the airport and went through security. Yeah, that's your single most common profile of a crime committed by a criminal. As far as population density, turns out Suwannee County is one of the most dense for concealed carry permits per capita anywhere in the state. Yet by no means are you the highest crime area in the state. And for that, I think, one reason I moved here, I was in criminal justice all my life. Okay? I don't buy a house someplace where the cops suck and the judges suck and the justice system sucks. Okay, right now, I think Buddy Williams is an excellent chief of police. I think Tony Cameron has led a superb sheriff's department, and Sheriff Williams did so before him. Blair Payne, I think, is a splendid public defender, and I have no problems with how I voted for Jeff Siegmeister, your current state's attorney. So I do not worry about you being victims of the next Angela Corey, or the generation before her